Okay, thank you and welcome everybody to the Seoul District Business Association Small Business Basic, What to Expect When Retaining an Attorney for Your Business Needs. So if you're a small business owner who's seeking legal counsel, we've got two legal professionals on our Zoom call today that are going to walk us through some scenarios and some strategies for you to consider. They are Bryson Davis and Hans LaForest. And Bryson and Hansari, if you could introduce yourselves and give the group a little bit of a background, we'd appreciate it.
Yeah, so I'll go first. My name is Bryson Davis. I'm a business, nonprofit, and real estate attorney based out of Vancouver, but licensed in Oregon and Washington, and have clients in both states. I've been practicing for about 10 years, and I'm transactional.
And good morning, everyone. My name is Hans LaForest, but everyone calls me Hans. I'm a civil trial attorney practicing with Sussman and Shank here in downtown Portland. Just as a little bit of background about myself, my practice deals with the representation in litigated disputes of various businesses. Some of them include insurance defense disputes, and they range from industries such as transportation industries to telecom industries. Before my experience as a civil litigator for the past 5 years, I started out my career as a prosecutor, worked my way into criminal defense for a number of years out of state before coming to Oregon in approximately 2018. And starting my practice in civil litigation. So good to connect with you all.
Thank you, gentlemen. So we're going to proceed with your presentation, but those of you on the call, the chat is active. So if you have some questions or comments, we can put them in the chat and then we'll address them at some point. And I know the gentleman can see the chats as well. And of course, we'll leave some time for some Q&A as well. So please use the chat, and we look forward to your comments and questions post-presentation. Thank you.
Yeah, so as we just said, I'm Bryson, and this is Hans. This is our contact information. It's also on the last slide. And if you need a copy of the slides, we can send a copy of it to you, or Fawn has a copy that she can share with you. If you have any follow-up questions on anything that we say today, feel free to shoot us an email or give us a call. We'd be happy to chat with you more. So we're going to start with looking at kind of when does your business need legal help? Why might you want to call an attorney? So there are a few critical moments of business that really that start involving legal issues. Several of the transaction spaces, especially early on, where you're doing entity formation, you're doing agreements between owners, things like that, figuring out your tax structure. If you have government compliance, if you got employees doing employee contracts or client contracts, and if you're selling or merging your company into other companies, and then the obvious of if you have legal disputes, if an employee has an issue, if you're fighting with your other business owner, if you have an investigation by government regulators. All these things are critical moments that sort of involve various types of legal issues and various types of legal approaches.
So one of the things that we want you to think about when you come to these junctures that Bryson just mentioned, and you're thinking about what is the goal of an attorney in this particular business event, is a concept that I think is common among people that work in construction, people that work in engineering, the idea of measuring twice and cutting once, right? Obviously, you want your attorney or your legal counsel to obviously resolve the legal matter and do it in a manner that's effective for your business and solves the issue. But there's also some additional goals that I want you all thinking about when you engage an attorney. And that second goal is you want to make sure that whatever work your legal counsel does for your business at that particular moment sets a good precedent going forward. So for example, if you have an employee contract and you have an employee dispute, how you resolve that dispute and how your legal counsel chooses to resolve that dispute can set a precedent going forward if you have another dispute with other employees. And you see this time and time again, whether it's a customer or client issue or other issues. So establishing good precedent and good practices for your business up front when you engage an attorney on a matter can have ramifications down the road. The other thing that you also want to keep in mind as part of the goal of engaging an attorney is identifying future legal issues. And this is particularly important if your business is one that has compliance issues, that you've got laws and regulations, whether on the state level, the local level, or on the federal level, that you need to be privy to, or other matters. You're going to want your attorney to be able to inform you that, hey, there may be an issue that you may not see today and may not be an issue for you today, but it might be an issue going forward, and here's how to resolve it. So again, the concept here is you want to measure twice and cut once in terms of resolving the legal matter, but also there's additional goals that your legal counsel of choice can help you resolve later on down the road. So the first step in terms of getting legal help is, what is your legal issue? And we're going to talk a little bit about that. The first idea of trying to identify what sort of attorney you want to bring in is making sure you have a good grasp of what the issue is that you want your attorney to solve. Okay? And there's two concepts or three concepts that we really want you to think about in this regard. Number one, what is the area of law that necessitates or requires you to bring in an attorney? And the reason why that's such a critical issue is because the law is vast and lawyers do different things. So for example, we have this list up on the PowerPoint slide that sort of identifies the different areas of law that lawyers practice. And obviously it's vast. I mean, you've got commercial litigators, you've got criminal law, family law, businesses in general, but you can delve into business, personal injury, estate planning. And so when you think about engaging a lawyer, the biggest thing that you want to do in terms of evaluating the law is identify the area of law or the practice area that your legal issue comes up in and plan accordingly. The same thing can be said for your type of industry, because the same way that you're going to have a lawyer that practices in intellectual property, and what that lawyer does may be different than a lawyer who practices in employment law versus commercial litigation, there are lawyers that also focus on specific industries. So there are construction lawyers, lawyers that operate and have knowledge of media entities and media rights. There are lawyers that practice agribusiness, right, and farming, right, and the list goes on and on and on. So these two areas, right, identifying the legal specialty that you need legal help in, but also making sure you've got a keen understanding of your industry, those are two ways that you can narrow the focus of trying to figure out what kind of lawyer that you're going to need to engage in.
And one thing you'll start to notice is attorneys specialize a little bit more as you get further up market. So the more expensive firms, the larger firms will have a little bit more industry specialization. For smaller firms or more local firms will be a little bit more general. One more area too that to think about here when it comes to your legal issue is whether you're looking for a transactional attorney or a litigation attorney. Now this is attorneys who are focused on doing things like transactions or things like contracts, mergers, just kind of general advice, advice about how to help with your policies, and just general business stuff. A commercial lease would be a good example of an issue that a transactional attorney would focus on. Litigation attorney is somebody who's going to represent you in court, and so you're going for a litigation attorney typically when you have a dispute with another party, and especially when that dispute gets to the point where one party is thinking about suing the other party. Some attorneys litigate, some attorneys do transactions, some attorneys do both. I know one attorney that I work with here does both, and some attorneys might focus in a particular area of law, like employment, and do both transactions and litigation. And so you'll see a different variety of attorneys based on what they like to do and what they've specialized in. But the type of attorney is going to determine how effective and how tailored for your issue they're going to be. So now we're talking a little bit about what to look for when you're retaining an attorney. So when you're retaining an attorney, do a little bit of homework prior to hiring somebody. Again, we talked about specialization in industry. That if you've got, again, construction, if you're in the construction industry, there are attorneys who specialize in construction matters. If you are having a specific employment issue, specializing in handling specific legal matters, an employment lawyer is going to be key. If you're potentially going through a divorce or have family law issues, have child custody issues, family attorney is going to be who you want. So do your homework with what we talked about before, just to make sure that you are headed in the right direction, and that'll save you time once you start picking up the phone and calling various law firms. Another way to approach it, and one way I very much recommend, is to seek out referrals. There are several types of professionals who work with attorneys on a day-to-day basis. For instance, real estate brokers, business evaluators, sometimes insurance professionals, CPAs. A lot of them will know attorneys and will have a little bit of a network and know somebody who's good and could potentially refer your matter or you to them for the matter that you have. Also, if you already have an attorney, like say you have a business attorney, but you need a family law attorney for your particular issue, most attorneys know other attorneys and know attorneys who are really good in the specific areas, and your attorney that you've already worked with will have a good idea for your budget as well, and will know exactly which type to refer you to.
So once you do what Bryson just indicated, where you've done your homework, you've sought out some referrals, you've heard from some different folks, hey, there's a handful of attorneys that may be able to handle your matter. You may get to the area where you're evaluating between 1 or 2 or 3 different attorneys. And one of the guideposts that you want to have in mind when evaluating an attorney is that generally, and this is the same for the legal industry versus maybe any other industry that you have, experience is almost generally always a plus. There's a life cycle for attorneys the same way that there's a life cycle for different sorts of professions. Generally, when you're fresh out of law school, year 1 through 3, when you're working as an attorney, you're learning the ropes of your practice. You're learning the ropes of the particular area that you're practicing law in. So years 1 through 3 and 1 through 5, those are the types of attorneys that are getting their sea legs on, right? As soon as you hit year 4, year 5, and of course, folks, this is dependent obviously in the practice area. There are some practice areas, bankruptcy, things like that, where there may be the learning curve may be higher than others, but generally, once you hit year 4, year 5, year 6, you start to see lawyers climbing up on that learning curve and really settling into a practice area, really getting a level of competence that you're just going to accumulate naturally and you don't necessarily have when you're fresh out of law school. I identified the sweet spot of years 8 through 15. I say that this is a sweet spot just to say that this is kind of a rule of thumb. This is not to be applied across the board. But when you've got an attorney that's in that year 8 through 15 range, generally what you see in that range, especially when it comes to representing businesses, is you see attorneys that have a level of competence where they can solve a lot of different issues in that particular area. And they have something called lower billable hours, and we'll get to billable hours later on in this presentation, than perhaps an attorney that's more seasoned and that has that 16-year, 17-year, 18-year experience. So years 8 through 15 tends to be a sweet spot. And then obviously, once you get past year 15, year 16, year 17, year 18, now you're dealing with seasoned lawyers. These are individuals that have, hey, 16, 17, 18, 20 plus years in the game. They've seen a lot of different variations of some of the problems that your business may be incurring in the course of that professional life. And so their ability to assist your business in a timely manner, in a manner that's very effective, is pretty high. And with that experience is obviously going to come as higher billable rate, which again, we'll talk about billable rates later on. Obviously, all businesses are going to be cost effective when it comes to their services that they're engaging. And of course, legal work is no different. There's going to be different price points for not just the attorney experience that you're engaging, but also the type of practice that attorney may have. So for example, there are solo attorneys and solo practitioners, and they have certain price points. Small firms have certain price points as well, and small firms tend to be able to offer effective legal services in a way that perhaps based on the exclusivity and the particular practice area where they practice, there may be cost effectiveness for your business where perhaps a mid-sized firm and a larger firm may not necessarily have that cost effectiveness. Again, general rule of thumb. Mid-sized firms and large firms tend to have multiple attorneys that if you have, depending on the type of practice that you have, you can have both a partner and something called an associate working on your case. In addition to that, they may also have paralegals and legal assistants that may be able to provide efficiencies to the type of legal matter that you have by delegating that work in a manner that's effective for you. So again, this is sort of a holistic view of cost being a factor and also experience being a factor when you're evaluating attorney A from attorney B to attorney C.
And again, these are also just kind of general rules of thumb. Obviously, you can have attorneys who've been practicing forever who aren't particularly good. You can have attorneys who are relatively new who are amazing. This is just kind of giving you a general idea of if you know nothing else, how to approach different firms, different types of attorneys. So let's get into a little bit some of the tips and misconceptions about picking an attorney. So one common misconception is you have a dispute, you're arguing with another party about some issue, you've got your attorney, and the other party hires their attorney. So your immediate thought is, oh no, now they've got an attorney, this is going to be significantly worse. And a lot of times that's not necessarily the case. One of the ways to kind of balloon your attorney's fees and the cost of you dealing with a dispute is having your attorney effectively trying to educate the other side. If the other side has an attorney, both attorneys are going to have a pretty good initial impression of how solid ground each party is in the dispute. And if you've got a particularly good case, or your side's particularly strong, the other side's attorney is actually going to do some of the work for you in convincing the other side that they don't have much of a leg to stand on. And so oftentimes the other side having an attorney as well as you having an attorney can be a good thing in order to resolve the dispute more quickly.
And so these next 3 points that we're going to discuss dovetails into what Bryson just mentioned about having an attorney both on your side and also the other side up front can oftentimes help resolve disputes or solve the legal issue at hand. And so with respect to the first 2 bullet points, okay, we've got, having the details of the transaction and dispute organized and documented. That's going to help us as attorneys be efficient. And here's the reason why. And I'll give this from the perspective of a litigator. Whenever I'm engaged by a business and I hop into a case, let's say the case is an employer-employee dispute, oftentimes what I'm looking at is I'm trying to find what are the documents that help me figure out whether or not the claim that, for example, is being brought by the employee against the business is valid or not. So what this means is I'm looking for emails. I'm looking for communications between the business and the employee as to the contents of the dispute, what the business said, what the employee said, the contract that was signed, which we're going to get into later on in this presentation. If you've got a good system where you save these important documents, save important communications, or at least have them available, where if you engage an attorney, that attorney can get it rapidly, efficiently, and analyze it and be able to give you a sense as to how this may play out down the road, that helps the attorney and that helps the resolution of the legal dispute. Whether that legal dispute is going to proceed and that attorney is going to tell you, hey, you've got a case, why don't we take this to arbitration, or why don't we file, file our answer and say X, Y, Z, or they tell you, hey, this might not be the case that you want to bring before an arbitrator or judge. Let's try to see if we can engage in some sort of dispute resolution process. That helps. The same thing goes with the second bullet point over here of having clear policies and documented actions. And this, again, dovetails into the idea of having a good record-keeping system of the communications that are made with different individuals, whether it's an employee, whether it's a customer or client, whether it's a partner, a strategic partner. Those things can help head off those claims at the beginning. And then finally, again, a lot of the work that your attorney is going to be able to do for you is going to be contingent on having that information up front. No attorney, and especially I'm speaking specifically from litigators, no litigator wants to find out during a deposition after a couple months of discovery a smoking gun email that should have been discussed between you and your attorney up front, right? And so this goes into the record keeping issue. You want to make sure that all potentially relevant information, whether it's emails, key documents, text messages, all of that is turned over up front so your attorney can help you evaluate what a claim, can help you evaluate a transaction, can help you evaluate the course of how your legal dispute can best go to help solve the business issue.
And from the transaction side, it's the exact same. Nothing is more frustrating to clients than having a bunch of extra time on a bill because I only had limited information, started going down one path and then had to readjust everything because I get another piece of information later. And so giving all the information that you can think of up front and being clear about exactly where you want to go with the transaction or your litigation goals will be key so your attorney isn't spending time going down a route that is not going to be productive to your goal. One last thing, and this probably applies a little bit more on the transaction side than it does on the litigation side. There are several areas of law where attorneys are good, are good references, are good advisors, but it's also in the realm of other professionals as well. A really good attorney will let you know if there is a type of issue that another cheaper professional could help you with just as effectively and potentially cheaper. I think of CPAs being able to help with certain tax filings. I think of having an HR professional being able to help you with employee management, employee issues. There are several other supporting professionals that attorneys that you can supplement your attorney with to help get some of these things done. And a good attorney will help you find those and spot those. So let's talk a little bit about budgeting and cost for legal work. So legal work comes in various sizes and shapes, various levels of complexity, various levels of expense. Very small matters and transactions can be in the $500 to $5,000 range. So this is like you are forming a pretty simple business. If you are doing a simple form contract, if you are having your attorney review your lease, all of these things are in the low four-figure, maybe mid-high three-figure range when it comes to cost on the transaction side. You can get a lot of simple things done transactionally under the $5,000 range.
And the same thing on this point goes perhaps for litigation as well. For again, the key word is small matters. So I'll give you an example. Let's say that you've got a customer that they're 3 months in arrears. You've got an account receivable that's approaching that 4-month, 5-month mark, and you just need them to pay up and get current with their bill. Perhaps engaging a litigation attorney to send out a simple demand letter, is something that will cost maybe just a couple of 5 hours, 6 hours tops, right? Limited engagement for that purpose, is something that you can easily do below that 5,000 mark, depending again on the billable rate of that attorney. The same can be said for small cease and desist matters where you're not really looking to take it all the way to court, right? That's something where perhaps you can get it under that range, depending on the amount of hours that you're asking your legal counsel to engage on that particular matter. Even if there's a case where you've got something where you wanted to go to mediation, you've got a contract, you've got a dispute with someone, in the contract there's a mediation clause. Hey, before we pick up the swords and start duking it out in court, we're gonna mediate any sort of dispute under this contract. Even then, you're thinking about perhaps 15 to 20 hours, 25 hours. Perhaps that's not the $5,000 range, but that's something that can be done affordably in comparison to some of the larger matters, which I'm going to get into right now. And the key thing here is this: larger matters are expensive. Litigation itself is a very expensive proposition in the system that we have. And that's even for litigation that doesn't get to a jury trial or a trial before a judge. The vast majority of cases in our system, when it comes to litigated matters, do not get resolved by a jury, do not get resolved by a judge, but instead get settled before it gets there. But that doesn't mean that there's not costs and pretty significant costs, depending on the type of matter, associated with that. The cost of something that is called discovery, where in the course of litigation, both sides are entitled to find out information that the other side is going to present at trial. So for example, you can ask that other side to produce certain key documents. You can ask for something called a deposition, where your lawyer will depose or ask questions under oath of certain key individuals that will have relevant information for that case later on. Discovery costs are expensive. So litigation can start at a floor level of, let's say, $15,000 in terms of the retainer, right? Depending on the lawyer that you engage, but can easily balloon up to and over $100,000. I've got a case right now that is we've just set up a budget for $200,000 in terms of litigation, depending on whether or not it goes before the arbitrator, depending on the issues. So large matters, I want you to keep in mind, especially in the litigation area, and Bryce is going to talk about the transactional area, large matters can be very expensive. So keep that in mind in budget.
Yeah, and then there are complex transactions as well. You know, luckily for most small businesses, you're not going to have the level of transaction that really digs you deep into the five or low six-figure range. Those are mostly transactions between large publicly traded companies. But the more complex transactions can end up running up the bill. So if you're doing a securities offering to raise a bunch of money from passive investors, if you've got a really complicated business structure, if you are purchasing or selling a business for several $1 million, the details and the work in those transactions can be to the level of in the $10,000 to $50,000 range fairly easily. And so when it comes to looking at your budget, looking at your costs, and how you approach hiring an attorney based on this information, you really should adjust your goals and your expectations with the idea in mind that complexity and size is going to greatly increase cost.
And so just picking up on where Bryson picked off, and I will say with respect to complexity, the complex transactions, the same thing goes for complex litigation. If you've got more parties or there are novel issues in the law that are going to have to be litigated, you can expect that may add to the level of complexity. It may add to the budgetary requirements in those particular matters. But as we have in this first bullet point over here, the more money, the more funds that can be dedicated to that legal matter, the more flexibility that's going to give you in that legal matter. With respect to litigation, here's what that means. If you've got a budget where that, hey, I've got about $50,000 that I can dedicate to this particular legal dispute, okay? And that's something that your litigator obviously knows upfront, and you speak with your litigation counsel on this. Well, that's going to afford you some degree of flexibility to do some litigation. And perhaps, once you're approaching an area where, hey, this dispute is right, we need to, perhaps get this settled, perhaps look to see if you can have an exit rate. Perhaps look to see if there's a way that you can reach some sort of accord on it. Let's say that budget is bigger. Let's say that budget is $100,000, right? Well, in those particular circumstances, then you've got a degree more flexibility in that case, right? What does that mean? Well, not only do you have the ability to litigate in terms of conducting more discovery, perhaps you can engage your counsel to do something called a summary judgment motion, where instead of it going to court, you're presenting an application to the court that, hey, on this particular issue, we feel that no reasonable juror can see this particular issue otherwise. So this court should find for us as a matter of law on this particular issue, whether that issue is liability or damages, what have you. Again, that gives your litigator more flexibility to do more things in the particular litigated dispute.
There's a question in the chat of what would be a typical budget for entity formation or adding a partner to your business. Entity formation, if it's just a simple like a single member LLC, that could be done sometimes for under $100,000. If you are doing something a little bit more complex, and this kind of gets to what we were talking about. If you've got 4 members and each person has different roles and there's different tax considerations, or if you've got some people who are going to be active in the business and some people who are going to be passive and just investing in the business, then it can go up from there. And the level of complexity will increase from that sub $5,000 mark for a simple single member LLC. And then same with adding a partner to your business, though in some ways it can be the opposite, where if you're going from a single owner business to a multi-owner business, there's often things that you don't really have to incorporate in your single owner business because you're not worried about the interaction or dispute between owners because there's only one owner. And when you add a second owner, then you have a lot of other things that you have to account for, and the complexity jumps up a full step. If you're adding a third owner when you already have two, and the third owner is generally works well with the policies you already have in place, and oftentimes that can be very simple. It can be just a matter of signing a couple of documents that have already been drafted. And so, you know, it varies in range. It varies by the complexity of what's going on, and it varies by where you are in your current business preparation.
So this is why when you have those first initial meetings with your chosen attorney, you want to make sure, and we've alluded to this, but upfront you want to make sure that you set up a budget and have clear expectations and have a frank conversation with your attorney as to how much the budget is for the work, what the work is, what you want your legal counsel to do, and what their estimate is for how much time it's going to take and how much it's going to cost. Having that conversation up front is going to allow your attorney to work within the confines of that particular budget. So, for example, if you've got a legal issue where you know that you're going to have to evaluate whether or not someone that owes your business money and you want to go after has enough assets potentially to satisfy that, right? That's something that potentially you want to make sure that you let your attorney know if you've only got perhaps a budget of only $10,000, because that may not be something that you can do with that particular budget, again, depending on the legal issue. Talking to the attorney upfront can allow you to have that conversation, set those expectations, and avoid that surprise bill later on down the line.
And you know, attorneys can be flexible. You know, we know that not every client is always preparing to have a legal issue or preparing to have an idea or an issue pop up. If you are ended up with a bill from your attorney that you can't pay, really, guys, with all creditors, communicate with your attorney, say, look, this is my situation. This is when I think I'll be able to pay. Good communication throughout gives the attorney more comfort that you're going to eventually pay the bill, and allows them to be a little bit more flexible, which can be especially helpful if, like in the last bullet point, you have a firm that charges late fees for outstanding bills. Good communication, paying consistently to pay down a bill can help maybe even persuade your attorney to waive those late fees.
And just on waiver of fees, you know, again, having that good relationship with your attorney. I know part of my practice is, you know, we sometimes, depending on the amount of work, will waive fees. We sometimes will write off certain costs. But again, that depends on the level of relationship that I'll have with the clients and those expectations as to what their expectation is, the amount of hours that I need to put into a given particular task. So the key thing, if you take nothing from this particular slide away other than this, is to make sure you have those communications with your attorney and have that open door communication up front.
So we're going to use an example of Jimmy Bob's junk removal as an example client to kind of go through a few example issues. So to give you a little bit of context, this example client, local junk removal business, there's two owners, one's 60%, one's 40%, several employees, a range of job size and job costs, and they have, you know, large trucks, significant equipment, and occasionally they deal with hazardous substances. So let's talk briefly about, you know, transactions and contracts. The very first thing, and this is a key point that I can't stress enough, is if you have an agreement with somebody else, write down what you agree on. And even if you don't hire an attorney, writing down the points that you agree on and what each party is supposed to be doing, what the price is supposed to be. All those things can help clarify things if people have a misunderstanding and if you have a dispute about what's happening later on. Oral contracts technically exist. And one of the first things that we learn our first year in law school is oral contracts can be enforced, but you really should not rely on them. Having that written agreement really provides you the evidence of what the terms were and what each person agreed to. There's also a few areas in the law that don't allow you to do oral contracts, like purchasing real estate, certain size transactions. It's called the statute of frauds. And so always write your agreements down, even if you don't hire an attorney to help you do it. Contracts in general are really a vital part to all businesses. If you've got vendors that you often work with, if you've got types of jobs that you always do, having good contract forms for transactions that you regularly engage in can be really helpful for you to regularize or what you have to do for those types of transactions. You can have a familiar and consistent method for dealing with disputes if something happens in those types of transactions. And a good agreement can really be the difference between recovery and non-recovery in some of these issues. So having attorney's fee provisions, having clear and defined terms, having clear timelines, et cetera.
And just to jump in, Bryson, on what you mentioned, when we talk about good agreements, there are particular provisions as a litigator. If there's ever a case where you come to me, for example, and you're like, hey, listen, I need to sue breach contract because this particular customer hasn't paid or what have you. One of the first things that you're going to do as a litigator is you're going to go to that form and you're going to evaluate what are the provisions in there. An attorney fee provision, that's something as a litigator that's particularly important in modern litigation, in business litigation, because oftentimes what that'll do is that when we say attorney fee provision, what we're talking about is we're talking about a clause that says, hey, if you are a prevailing party, if someone sues for breach of contract and you prevail, you win, for example, okay, the winner gets to recover their attorney fees. That is huge in modern business litigation because that's going to allow me as a litigator, if I get enough evidence during the course of discovery that, hey, we've got a good shot at winning this, I'm going to send over an email, say like, you really need to consider settling this case, because if you don't and we win at trial and we win before the judge or the arbitrator, we're going to follow this attorney fee provision. We're going to be asking for our attorney fees, right? And oftentimes that ends up being a really good hook for the case either settling, or obviously if you end up prevailing at trial, you actually get an award of your attorney fees. So again, good agreements, as Bryson mentioned, having those provisions ultimately ends up helping litigators down the road if there's ever a problem.
And if you have two parties sending their form contracts and you send your form contracts, make sure you agree on which one you're using before you start providing the services. There's a way to figure out which of those terms will govern any disputes that arise, but it's going to be a lot easier if everybody's got an agreement as to which contract is the governing contract. Another piece of contracts is you want to understand what you're signing. Again, this is really easy if you've got a form contract that you use over and over and over again that you worked with your attorney to build. But even with contracts that you don't, and even if you hire an attorney, you're going to want to make sure that you read through all the contracts that you sign. The more money and the more risk that you have, the more important it is to know what's in it. And as a client, this includes more than just your basic order terms, just the payment price. There's a bunch of other terms that can impact the transaction and can dictate things that you need to do throughout the relationship under the contract. Have any questions on any of these terms? If any of them don't make any sense, that's where you ask your attorney and say, what does this term mean? What do I have to do here? So in transactions and contracts, when should you hire an attorney? When is an attorney going to be valuable and really help you with the transaction? So transactions with values over $10,000, if you are buying something that's worth more than $10,000, if you are entering into a commercial lease for a good amount of time, those have enough value that if you mess them up or you have a dispute over them, they can cost your business a lot of real money. And so investing a little bit up front to make sure that you understand what you're getting into and all the terms that you want in that transaction are included. It can be immensely valuable. Also, like I mentioned a second ago, regular transactions. Even if you have smaller transactions with clients, like in the junk removal case, if you've got a lot of $1,000 jobs, hiring an attorney to do a contract for one $1,000 job isn't going to be efficient. But if you've got $20,000 jobs a month, and this is something that you're doing every month, hiring an attorney to do a contract to govern those types of jobs will again be a cost up front, but will help cover you for a bunch of things that you do down the road and really help you organize your transactions and lower your liability risks. Which is another item where transactions and attorneys can be really helpful are areas where you might have a high liability risk. So if you're dealing with hazardous chemicals, or you are doing something that maybe doesn't even have that big of a direct dollar value, but if you mess it up, could cause a lot of damage. Bringing an attorney up front, they can help you spot those risks, as well as help you mitigate some of those risks in the contract, limiting your liability to certain caps and things like that. Again, long-term business relationships, just like regular transactions, and then company governing documents. You know, we talked about adding a partner to your business earlier. Having clear and defined business management policies, business management roles, and procedures, and what to do if your business partners disagree about the direction of the business, disagree about a certain decision. It will really help. Having good documents can really help you solve those issues and resolve those issues without spending too much money hiring Hans to help you litigate it. You know, one of the key themes here is a little bit of preparation can go a long way. Hiring an attorney early can save you a lot of money if the relationship goes sideways. Again, streamline dispute resolutions, putting that attorney fee provision in the contract, and really being clear and having well-defined responsibilities and agreements and relationships.
Yeah, and just on that streamlined dispute resolution, this goes back to what we mentioned before. One of the things that we're looking at as litigators, especially in contract disputes, in addition to that attorney fee provision, is there a dispute resolution clause? Maybe you want to agree at the beginning, hey, if we ever get a dispute over this contract, whether it's with your employee or whether it's with a strategic partner, we're going to mediate this case first to save on the fees. Well, hiring an attorney or hiring someone like Bryson to sort of put that in the contract, think about it, make sure that it's there, that helps later on down the road if the relationship goes sideways.
Again, a few more examples, like I mentioned, form contract work, multiple owners, big commercial lease. If you're buying or selling real estate, whether it's commercial or residential, having an attorney can be key. I dealt with an issue where a client bought a house and neither side used an attorney, and the one side kind of got screwed in the transaction, but the other side forgot to do a major item, and so the one side was able to get out of the contract. if either side had had an attorney going into it, that transaction would have gone a lot differently. And again, reviewing a major contract for a large dollar job attorneys can be really efficient and can really help you out there. And then again, I can't stress this enough. Even if you don't hire an attorney, write your agreements down. So looking at Jimmy Bob's junk removal, a couple of examples of where attorneys can be helpful. So you had two owners, one 60%, one 40%. They decided they want to go in different directions. They decided, oh, we don't really see eye to eye anymore. This isn't working. Because they hired an attorney and they had a good operating agreement, which had clear buyout procedures and clear management procedures if there was a dispute between the owners, and clear voting procedures to determine how to deal with certain decisions. There was a procedure for the majority owner to buy out the smaller owner without interfering with the operations of the company. If the company grinds to a halt because the owners are fighting over this or that, then everybody's going to lose money because the company's not going to be generating money. And so having clear procedures, having clear buyout provisions, having clear understandings of how things go if there's a dispute between managers can be really key. Hiring an attorney for the purchase of a smaller junk removal company. So having an attorney review that purchase and help you draft updates or maybe even draft the documents themselves for that sort of transaction can really limit your liability for the actions that the previous company took. There's several different types of ways where the issues caused by the previous company can be translated to the new company. And there are several ways which can limit that so that the seller retains responsibility for those liabilities. And so having an attorney come in can help you really draw that line and demarcate where the seller's responsibilities and the new owner's responsibilities begin. And then, as we mentioned several times, hire an attorney to draft customer contracts can help you both incorporate important terms like attorney's fees, limit your liability if a job goes wrong, and make collection and other such processes easy and clear.
All right, so now let's get into policies and procedures. And this dovetails into what Bryson was talking about you've got policies and procedures, obviously, with the entity formation side, but hey, Jimmy Bob's may also have policies and procedures that are relevant with respect to, just making sure that we're on the right slide, with respect to employment, with respect to data privacy. So policies and procedures, when to hire an attorney, right? You may want to hire an attorney at the beginning of this business with respect to Jimmy Bob's, or let's say any business that you have. When you want to set up some sort of employee handbook to sort of determine what your employee policies, your employment policies are going to be. And that employment policy can range from everything to time off to some sort of escalated disciplinary provisions, how you handle wages, things of that nature. These are the sorts of things where if you're a type of business that is going to engage a certain amount of employees, and you're going to keep on engaging these employees, at some point it's going to be worth it to have an attorney brought in to make sure that you've got clear policies and procedures with respect to your employers and with your employees. So in the event that if there's ever a dispute with an employee, you can make sure that you're referring to that employee handbook, that employment handbook. You make sure that you have that employee at the beginning of their employment with your business sign off that they've received a copy of the policy, that they've read through the copy of the policy, that they understand it, and that helps protect the business later on down the road. The same thing goes for businesses that are going to be handling a certain amount of data. Okay, if you're in a business that's collecting user information, customer information, names, credit card information, those sorts of things. Well, you need to be aware in this current ecosystem, data breaches are a real possibility. And having a data privacy policy and having a lawyer that understands that and can help you craft those policies, and can not only help you craft those policies, but can help you craft a response in the event that there is a data breach, can ultimately help you avoid some headaches later on down the road. Now, as we mentioned earlier in this presentation, there are professionals in the sphere that can help provide some of those services. So there are professional HR consultant services, there are data privacy consultant services that provide them. But certainly, you'll want to make sure that you engage an attorney if you've got an issue that becomes complex. If you've got an employee handbook, depending on your industry, that's going to have to, deal with particular issues in your industry, it may be worth it, in addition to perhaps reaching out to a professional HR consultant, reaching out to your attorney. Again, even if you don't hire an attorney, and we're going to say this over and over again, decisions with respect to employment, decisions with respect to data privacy, those need to be documented and those need to be saved. If you don't write it down, make sure it's in an email somewhere. Make sure it's documented somewhere. Perfect example is in employee disciplinary actions. Let's say that you've got a situation where you've got an employee that, for whatever reason, you need to be able to institute some sort of disciplinary action, or maybe end up terminating for XYZ reason. Maybe it's a tardiness, lateness infractions, right? And all of a sudden, that employee comes back later on and says, hey, listen, I'm not treated fairly because you potentially have another employee that has the same sort of lateness infraction, and hey, I wasn't treated in the same way that other employees are treated. Well, you've got a problem if those employment policies, when it comes to tardiness, are not documented. If your treatment of your employees when it comes to disciplining them for tardiness is not documented. So those are things that, even if you don't hire an attorney, make sure that you retain, you have those documents.
So going back to Jimmy Bob's junk removal. So there's several areas, and especially when it comes to policies and procedures and different action that we take, where just calling an attorney to just ask a question or two about what it is that you're doing makes a lot of sense. So again, in the Jimmy Bob's junk removal context, maybe they get a wage garnishment for an employee who has to, was child support, went through the courts, and their paycheck's being garnished. And you've never done one before, you're not sure how it works. Calling your attorney, just talking for about 10-15 minutes about what the procedure is, what you have to do, and how you deal with it, can make sure that you confirm that you're doing things right, and can save you a ton of time and a ton of liability from doing things wrong. There's several items that where just a quick call to just confirm your initial impressions about something are correct can really save you in the long term.
Another area for Jimmy Bob's consideration and for all businesses is when you have agency investigations that need a response. One of the prominent ones that all businesses should be aware of here, in this part of the country, is a bully investigation, Bureau of Labor and Industry. Whenever an employee seeks to bring a discrimination claim, one of the precedential things, or things that they need to do before they run to court and file a lawsuit against their employer, is they need to file a claim with bully in order for that agency to investigate. Well, retaining an attorney, if you ever get notice of a bully claim and you're on the clock, or your business is on the clock to provide some sort of response as that agency investigates it, retaining an attorney can help you out. Number one, obviously evaluating that investigation, evaluating what's been said in that statement, and providing a response. But then also, number two, that attorney can also help you, again, uncover whether or not you've got a systemic issue. whether or not you've got a problem with your organization that is going to require some sort of change of policy, maybe the implementation of an employee handbook, maybe a change to the employee handbook so you can avoid future bully investigations. These are things that an attorney can help you out, especially when it comes to the agency investigation sphere. The other thing that you want to keep in mind, whether you're a business like a junk removal business like Jimmy Bob, or you're any other business, is whether or not you've got good safety policies, and an attorney can help you out there. When it comes to safety policies, you want to make sure that if you've got an attorney, that they can help document that employees follow policies that sort of show that whether it's reckless customers are at fault, or, for example, safety policies with respect to OSHA, making sure that those policies are documented. So if you do potentially have an OSHA investigation, if you're in an industry where OSHA is relevant, having those documented. These are other areas in the life cycle of a business where employing an attorney can help out draft those and identify particular legal issues. All right, so now we're going to get into disputes. And these next couple of slides, I've identified some sort of common disputes that, hey, Jimmy Bob junk removal can potentially have. But really, I want you all thinking about this from the perspective of these are common, not infrequent disputes that over the course of the life of a business can potentially come up. And I want you to think about how an attorney will be engaged to resolve that dispute. So let's go to this first dispute over here. Let's say Jimmy Bob's has a hauling contract with a particular customer, where that customer says like, hey, I'm going to provide you a certain amount of goods on a month-to-month basis, and you're going to haul them for me. Pretty valuable contract, right? Well, surprise, surprise, later on down the road, the customer fails to provide the promised amount of goods that Jimmy Bob's is supposed to haul, and then they cancel the contract, right? What's the issue that you want to be thinking of? And let's harken back to the beginning of our slides. This obviously is going to be a breach of contract. You had an agreement as Jimmy Bob's with your customer. They failed to provide their end. As a result, you couldn't fulfill your end of the bargain and they canceled the contract. That's pure, straight up breach of contract. The area of law that you're going to be thinking about is this is going to be something called commercial litigation. It's a commercial dispute between business A and business B, and I need a litigator to come in here and whether I want to get damages for the breach of the contract, or I want to pursue some other avenue, you're going to want to bring in a commercial litigator, a business litigator. Now, there's a couple considerations that you want to have in mind. If you bring that to me, as any litigator is going to do, they're going to take a look at the contract, right? And so if you've retained someone like Bryson beforehand, I'm taking a look at whether or not there's an arbitration clause. I'm taking a look at whether or not there's a dispute resolution clause. I'm taking a look at whether or not there was some sort of agreement at the beginning of, hey, if we ever have a dispute between one another, this is where we're going to litigate the dispute. This is how we're going to litigate the dispute. And as we discussed already, I'm looking at whether or not there's an attorney fee provision that's going to potentially act as a way for us to sort of hold that over the other side if we get enough discovery and show that we've got a great case of potentially settling the case or litigating this to conclusion, which is a jury verdict or what have you, a favorable arbitration award, and then asking for our attorney fees. The other consideration in the litigation sphere is whether or not there's additional claims that we may be able to bring beside breach of contract. Maybe as a result of this particular customer canceling the contract, Jimmy Bob's has an impact on Jimmy Bob's business or relationship with another customer. They lose another contract that depended on this contract as a result. Well, then we're looking at potential interference with economic relations claim. And that's an additional claim that I can add to the litigation suit, which again, that puts us in a strategic advantage of, just obviously the more claims you have, the more chances you have at being a prevailing party at the end, and also just improving the status of the claim that you're bringing. Also, we're looking at something called provisional relief. Let's say that as a result of canceling the contract, there was some sort of harm besides economic harm that your business is going to suffer. Let's say that, for example, in addition to canceling the contract, they're going out there and putting out bad information in the community about the business that as a result of that, you're going to suffer reputational harm. Well, then maybe we're going to go to court and get something called a temporary restraining order, a preliminary injunction, basically a court order telling them to stop engaging in that behavior. That's also something that you want to consider as a commercial litigator, and that's always something that I'm going to have in the initial conversation with the client. So let's go into the second dispute over here, which is more along the lines of a personal injury insurance dispute. Let's say that Jimmy Bob's rear ends a motorist, right? They've got an employee, they rear end a motorist, they're hauling hazmat, right? In that particular case, if you've got insurance for that, which you obviously should, you go to your insurance carrier, say like, hey, you need to sort of protect me. You know, there may be a potential claim from this motorist. The insurance carrier disputes whether or not there's coverage for this particular claim because they dispute whether or not your insurance coverage carried or covered the transportation of hazmat. So now you've got a claim against the insurance carrier, right? So there's two issues, right? Personal injury, but this is also an insurance coverage dispute. So obviously that's the area of law that you're going to have to look at. And the type of lawyer that you're going to engage is going to have to be someone that's well versed in the areas of personal injury defense, tort litigation, but also coverage counsel as well. The considerations that you want to have is that, you know, most personal injury cases where you're insured involves the carrier hiring the insurance carrier hiring a local counsel. So you won't have to engage a personal injury lawyer if your insurance carrier doesn't. However, in this particular case, the insurance carrier is disputing coverage, so you may yourself have to go out and seek defense counsel. The other thing that you want to do is you want to retain counsel for that coverage dispute, which we discussed.
Yeah, and another kind of similar example that I ran into, which kind of dovetails into the being prepared, doing things up front. This actually happened with a junk removal client of mine, is they purchased the assets through an asset sale of another junk removal company. They used me to do it. We went through an asset sale instead of buying the business, the company itself. And then there was a claim, an Olympic fencer had been climbing on one of the junk removal trucks and had injured their foot while it was owned by the previous owner of the company. Because it was an asset sale, once they got sued, I contacted their attorney and said, look, we did an asset sale. We're not liable for this. The liability stops when the business was sold. You can only recover from the previous owner. They saw that and they were able to drop my client from the suit. But that came because they were prepared. They went through the right type of transaction for what they were trying to do and limited their liability to prevent them from being brought in later.
All right, so the final dispute example that we have over here is, you know, a good old-fashioned employment dispute. Let's say Jimmy Bob's has an employee. This particular employee had asked repeatedly for medical leave, paid medical leave, which she felt she was entitled to under the terms of the employee handbook. For whatever reason, Jimmy Bob, you know, whoever was sitting in HR wasn't able to facilitate that. She ends up leaving. She ends up turning around and suing the company, right? What's the issue over here? Obviously, this is an employment issue. When you have paid medical leave, right, you've got a potential wage issue as well. And depending on the medical issue for which she's leaving on, right, let's say that this is a medical issue that involves some sort of what we classify as disability. And under the law, the definition of disability can be broad. You may also be looking at a discrimination issue as well, right? So the area of law that you're looking at is employment law, and the type of lawyer that you're going to want to engage is an employment lawyer, preferably in this case, an employer side employment lawyer who is well versed in the ideas of defending against these particular employment issues, wage issues, and potential discrimination issues. The big consideration as the litigator, and again, we're going to sound like a broken record. But if you bring this from the litigation perspective, I'm looking at those key critical documents at that initial meeting with the business owner. So I'm looking at what the employee handbook says. I'm looking at those key critical emails. Every time she emailed or texted like, hey, I need, time off to take care of my back or my knee or whatever it is that she was asking medical leave for, what was the response? Was there something that she needed to do first before that? So these are the key considerations that you want to have, especially when engaging in employment or in a litigation, a litigator, but especially an employment lawyer in these particular disputes.
So we've got about 10 minutes left. If people have questions or issues that they think we can help with, feel free to chime in and ask them, and we'll answer them to the best of our ability.
Nice, thank you, guys. Mike, I know that you had an issue that you want to bring up, Mike, if you're there.
Yeah, can you guys hear me?
Yep.
Hey, so I had this contract with these guys over in Tigard at the mall there, and we needed to get certain insurance and bonding in order for us to be able to do this job. But what we were doing was basically subbing out that work, and what me and the owner had agreed to was that the owner would pay for any additional bonding insurance that was needed. And this was discussed with the person that I was subbing this work out to as well. And well, things started going bad. And that guy that I was subbing that work out to, he ended up getting canned. And I mean, I guess he had like some personal problems going on in his life, and he wasn't able to do any more of the work. So they ended up finding a completely different contractor. When after everything was said and done, I was reached out to by the insurance company, saying that I was in debt for like $6-7 grand or something for some payments that wasn't made to the insurance policy. And so I reached back out to those guys and I said, hey, this wasn't part of the deal. I thought you guys were going to pay for this. And they said, oh, well, that's, that was something, we closed that out and we went with a different contractor. I said, I know, but while AJ, the guy that was doing the work, was there, he didn't, nobody made the payments to that insurance, so what's going to happen now? Are you guys just going to flake on me now, or what are we going to do about this? And the last thing I heard from them was that they were going to try to work it out amongst themselves, but I still haven't heard back. And the last I did hear about from our sub, well, he wasn't doing too good. He was looking for work or whatever, and he was trying to get me to do some more jobs with him. I said, man, we tried to do that other job with you, and it went bad, so I can't do any more work with you. I mean, at least not until you make things right with the insurance, with the money that you owe, because it looks like I owe them, and I wasn't part of that project. I got it and I subbed it out to them because that was the agreement that we had amongst each others. And we do have that in writing, but I'm no lawyer. I don't know nothing about the legal matters and how to go about stuff like that. So I wanted to ask you guys, if you could give me some advice on that.
Yeah, so there's several things here, and I'm going to kind of use your example to touch on a few things, and then we can touch a little bit on maybe your next steps. The first is, kind of, as you mentioned, you've got a relationship between several parties. So you've got the client, you've got the general contractor, you've got the subcontractor, and you've got this specific term about who's going to cover this type of insurance for the job going forward, and when is that coverage and that responsibility going to terminate. This is where having a good contract up front makes those terms clear, makes it clear when someone's responsibility begins and when their responsibilities end, what terminating the agreement does to certain types of responsibilities, and whether or not, if something happens during the transaction, if any of those responsibilities get shifted. So that's the first thing, and why, again, what we talked about earlier, having the stuff done previously helps make those things clear. And going forward, and I think thinking about something of this size, because they're requesting payment for under $10,000. So hiring an attorney to do a full litigation is probably not going to be your most efficient use of your money, because it's going to cost too much unless you're able to get attorney's fees from it. But hiring an attorney to just look at the contract that you have, listen to the facts as they come out, and say, look, this is what I think, who I think is probably should owe this and probably should pay this. And sometimes we're in the unfortunate position of telling a client, you came with us with this thing. This is unfortunately going to be something that you've got to pay. Sometimes it's not. Sometimes we say, yeah, no, you're right. This is not something that you owe. And then you can go back and then sort of negotiate the fees based on the terms of the contract and what actually happened. And so taking that first step to say, hey, can you look at this for me? Can you tell me what my liability here? What is it that I owe? You're not going into full-on litigation. You're just basically doing a preliminary evaluation. That would be my advice for your next step.
And Mike, just to chime in on Bryson, which, Bryson, I 100% agree with. I know you mentioned advice, in the context of this is sort of like educational, right? For everyone here. Obviously, we don't know about your matter and we're not engaged. We can't necessarily give you legal advice right now without being engaged and actually reading through whatever documents are out there. But what Bryson mentioned, rings true. It's the idea here is that, your attorney or your legal counsel, even if you don't engage legal counsel, it's going to be critical to have an evaluation of what that initial document between yourself and that customer said with respect to the sum that you engaged, said with respect to, hey, that payment of, to the bonding company. And everything that comes with it, whether or not there's a prevailing party fee or anything like that. That's something that you'll want to make sure you take a look at after this. And if you do decide to go the route of engaging an attorney, you'll want your attorney to take a look at that too.
All right. Any other questions, Mike? Hopefully that answered what you were asking.
Yeah, thanks, you guys.
All right. Well, so I'm not seeing any other questions. You guys have our contact information, and it's in the slides. If you need it, we're also online, pnwbusinesslaw.com, sussmanshank.com, and we'd be happy to talk with you later if you've got other issues or follow up on something that we said today.